in great detail the powers and the authority of the President and how such power is to be exercised. Another reason that supports the finding that the President was not envisaged as an initiator of a popular initiative is the role of the President with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255, 3b of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the Presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This brings me to the inescapable conclusion that state institutions and state organs such as the Presidency cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the President and even the Attorney General sustained an argument that barring the President from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the President's political rights as protected for in Article 38.1 of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38.1c of the Constitution. However, there is an additional handle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38.1 grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the President, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the Presidency, which is a state organ. The Presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed who are the initiators and promoters of the impugned constitutional amendment initiative and not the President. An examination of the evidence before the courts revealed a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray his role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018, the official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the President was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the President of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with words